Any mention for unlisted matter? Any mention for unlisted matter?
May it please your lordships.
Yes.
Lordships, I beg to motion for listing of a PIL, my lord, tomorrow, my lord. The matter pertains to illegal mining of coal in the state of Meghalaya, my lord, which are being again illegally transported to Bangladesh.
In the usual course, it will come up. Yes. Have you filed it?
We will file it during the course of the day, my lord.
All right, then day after tomorrow. Yes.
My lord, deeply obliged.
From supplementary list, item number 1.
Lordship, this is an appeal against the, under section 37, against the order passed by commercial court. My application under section 34 was rejected, and the commercial court refused to set aside the award. Hence, I am here. Your Lordship, there is only one claim. 2 claims were already rejected by the arbitrator. Only one claim is there. That claim relates to the extension of time. The contract period, Your Lordship, was from 31/8/2009 to 30/8/2012. That was the contract period. So during this contract period, contractor gave 2 applications for extension of time. We have granted extension of time provisionally, reserving our right to levy the liquidated damages at the time of final extension. Now, after we granted the extension, contractor lost a claim against us for underutilization of his resources. His case is this, that the claim, Your Lordship, is between the contract period, not beyond the contract period. The claim is within the contract period, a certain period he chose, that for this period, I estimated that I will be completing the work of a particular amount. But due to contractual breaches on the part of the corporations, he could not complete that particular target, and therefore he is entitled for compensation, Your Lordship. My case is this, Your Lordship, that there are certain no claim clauses in the contract agreement which disentitles the contractor to claim any damages, save and except 2 things, that is extension of time and price escalations. For the contract period also, he has got the accelerations. Now, it's a case that according to contractor, he said this delay occurred because of me. And my case is that no, I have not breached any terms and condition of the contract. On the contrary, you have not put your manpower and machinery during this contract period, and that's why there was a delay. Now, the tribunal, Your Lordship, have not come to give any finding with regard to, Your Lordship, quantification of delay, and there is no finding that which party is responsible for causing delay. The tribunal has also not given any finding on the reasons for delay. According to the contractor, the delay in execution of the work occurred because there was a delay in handing over the working front, access to the project was not provided, and there was a delay in supplying the drawing and
Supplying the?
drawing, construction drawing. And one more reason was given by the contractor that during this period he was asked to do certain extra work. There is no finding of the tribunal on any of this issue, and without coming to any finding, the tribunal has given the award. Another aspect of the matter, Your Lordship, is this, that so far the prohibitory clauses are concerned. I have brought to the notice of the tribunal that there exist prohibitory clauses. The learned arbitrator has come to the finding that such clauses cannot foreclose the claim of the arbitrators. So also was the position in the commercial court. Commercial court has also given the same finding that these prohibitory clauses are violating of Section 23 of the Indian Contract Act. Your Lordship, I will just take to one finding of the Your Lordship will just come to page 86. Of my paper book. Lordship, I am reading Roman 4. The argument of the respondent that for delays caused on account of the respondent, the claimant has been fully compensated as per contract provision, that is by way of EOT and price adjustment, is not correct. Price adjustment certainly does not cover any losses due to delay, hindrance caused on account of the employer respondent. The Indian Contract Act is also clear in this respect, particularly Section 55 and 73 of the Indian Contract Act 1872. Once there is a breach of contract by the respondent, the claimant is entitled to be compensated for the losses, damages suffered by the claimant, Your Lordship. Now, even in this position of law is clearly set out in the case of ICM Airport Techniques so-and-so, Delhi High Court, where the Honorable Delhi High Court held the petitioner could not be expected to perform its promises until and unless the respondent was willing to perform its reciprocal promises. In view of the provision of Section 54 and 55 of the Contract Act, the petitioner was entitled to claim compensation for any losses which it may have sustained. Similarly, in the case of the Punjab National Bank versus Bijli Construction so-and-so, the Delhi High Court, while dealing with the argument that there were contractual provisions that barred the contracts, this is my case, Your Lordship, that there were contractual provisions that barred the contractor claim, despite defaults on the part of the owner held, the clauses of a contract cannot possibly foreclose a claim by the contractor for damages as a result of delay not attributable to the contractor. In view of the foregoing details, the AT is of the considered opinion that in this particular case, where the breaches resulted in a reduced progress to almost 32% of the scheduled target, the claimant is genuinely and legitimately entitled to be compensated for the losses, damages sustained due to underutilization of plant and machinery and labor, etc. Your Lordship, there are two things which I wanted to point out, that in order to claim compensation even under section 73 of the Indian Contract Act, there has to be finding about the breach of the terms of the condition of the contract agreement. There is no finding. No finding. So section 73 also has no applications. Secondly, Your Lordship, that whether the clauses of the contract agreement can foreclose a claim or not. He has referred to the judgment of the Delhi High Court, wherein even in the Delhi High Court, the word is possibly. They were also not sure. Possibly foreclose a claim by the contractor. Your Lordship will find that there are very specific clauses in the contract agreement which debars the contractor from claiming compensations on account of delay, and I just refer to Your Lordship clause 9 of the condition of contract, page 178. Lordship. Even on quantification of the claim, Your Lordship will find that a most hypothetical way of calculating the compensation is given, and there is no basis for awarding the compensation to the tune of 23 crore 12 lakhs 10,513. He had just taken the statement filed by the claimant and taken it to be a gospel truth and awarded this ownership, cost of equipment, cost of labor, how much labor was there, how much was utilized, site overhead, officer and staff, and even higher charges for DG sets which are specifically prohibited in the contract agreement.
What is NPV? NPV?
Your Lordship, I just forget the full form of this. I'll just get back to my Lordship. It's not coming.
So the total
Net present value. Net present value.
now you have only got this 23 crore.
Yes,
The rest of the claim has been rejected.
yes, rejected. In fact, we had claimed, the first claim was 40 crores.
This is sufficient justification, sir.
Your Lordship will see whether prohibitory clauses in the contract agreement.
Waste of time. It's not based on prohibited clauses at all.
Lordship, these.
It's not based on prohibited clauses at all. It's based on your admission. And the admission that you have, unfortunately, not read out to us.
No, Your Lordship, that was the comments which were sought by the contractor.
You must, first of all, show your admission before you place your case. If you hide your admission, you're gone, finished. You've hidden your admission. Come to page 85. Clause 1. There is no dispute between the parties with regard to loss of days in working, production during execution of works which have been clearly identified as attributable to the claimant or the respondent. The exercise has been carried out on all work fronts.
Your Lordship, this finding I have challenged.
Number one,
I have
there is
challenged.
no dispute. Number two, if you've challenged it, come to page 88. Last line of page 87. As per the quantification provided by the respondent on 3rd of June 2015, computation or reduction factor based on projected value of the work to be performed as per the work program and the value of the work affected due to hindrances which were attributable solely to the respondent, the statement of the respondent had grave errors related to the delays mentioned in the joint hindrance records and other mathematical errors also. Both parties were directed to resubmit the corrected statements. However, the respondent did not submit the same. The claimant has submitted corrected quantification as per above mentioned method in its written statement dated 8th of August 2015, and it goes on.
Lordship,
So delay is admitted. There were errors found in the quantification.
there is no dispute about the delay.
There is error found in the quantification.
But the parties who are responsible for causing delay, Your Lordship, there are three types of delay which are reflected. One delay attributable to me, other to the contractor. There are also delays which cannot be attributable to any party. These are because of the force majeure conditions. Now,
That is why the loss of value of work, which was 78.24 crore, that is the loss of value of work, has been reduced to 23.24
Your Lordship,
crore.
even if the unexecuted value of the work is 71 crores, so this is not the amount which he can claim from me. And he could not, according to him only, he could not execute the work of 71 crores. 71 crores. Now, had he executed that work, how much profit he would have won? Normal yardstick is 10 to 15%. Even in that case, it comes to not more than 7 or 8 crores. Now, the formula which the learned arbitrator has applied, that a contractor at his own, it's not a contractual provisions, at his own estimates that during this particular period he will execute the work of say 100 crores. And he could not execute, he could execute only 20 crores. So 80 crore, according to the contractor, is the loss. Then from 80 crore, he says that some delay might have been occurred on my part also, he gives concession and claim the amount. So also the learned arbitrator has adopted this formula. Even as a layman, your lordship will also see that loss of unexecuted work and those contractual clauses, your lordship, have got a bearing, your lordship. I may kindly be permitted to read the prohibitory clauses, your lordship.
Yes, go on.
Even on interest portion, your lordship, there are two clauses. One clause debars the arbitrator to award any interest. That is, arbitration clause itself says that arbitrator will have no power to award interest. And despite that, interest has been awarded. Pre-reference period.
Where is the interest? Where is the award of interest?
I'm just coming, sir. Page 92.
From the date of the reference up to the date of the award.
Yes, Lordship. The date of award. Now, your Lordship will just allow me to read the clause. Clause 70. Page 250. Roman 9. This is the arbitration clause under which the arbitration exercises the jurisdiction. Roman 9 says, the arbitrator appointed shall have no power to award interest on any claim. Refer to the arbitrations. No claim for interest or damages on whatsoever count will be entertained by the corporation with regard to the dispute, difference, or misunderstanding between the corporation. Now, this clause, your lordship, specifically takes away the jurisdiction of the arbitrator to award interest. And that part, your lordship, I may kindly be allowed to read one more clause, clause 24. I just read, your lordship will just come to page 200. Page 200. Page 200. Roman 7. Clause 24, Roman 7. No compensation is admissible other than whatever provided for in the clause number 20, suspension work for any extension of time if granted. Your lordship, he has accepted the extension unconditionally without putting me on notice that he also will be claiming compensations. The time was the...
You have claimed liquidated damages.
Lordship,
Have you claimed liquidated damages?
liquidated, we have said him that while granting the extension that
Have you claimed it ultimately or not?
ultimately it was claimed
It was claimed.
at the time of final extension.
Very good.
And even at the initial stage, a liquidated damages at the rate of 1%.
That's all right. You've claimed it, you must have got it. You must have deducted it from his bills.
Quite
That's
possible,
not
Your
in
Lordship.
dispute.
I have to
That's
do
not in
instruction
dispute.
on that.
But show us the case on interest, Ashoka.
Lordship,
Show us the case on interest, Ashoka Industries. What is permissible? What can be awarded by arbitrator despite such a clause?
yes,
Show us the judgment.
judgment of the commercial court. Your Lordship, 22 judgment, 22, 2 SCC 331.
What is the name of the case?
Name of the case, Union of India versus Manraj Enterprises.
No. Where is the original case?
Original, this has taken care of all the cases, Your Lordship. Ambika is distinguished in this case. Ambika is distinguished in this case.
First,
And Ambika
first. There are two Ambikas.
There are two Ambikas, Your Lordship. Both were under old Act,
You must be
1940.
completely wrong.
Lordship,
Don't make submissions before the High Court
Lordship,
when you are not educated on the matter.
Lordship will, here, that's why, Your Lordship, I am giving the latest judgment,
Show us.
2022, where they have distinguished Ambika case.
Yes, give us the copy of the judgment.
Lordship, I am sorry, I'll just make it and give it. Otherwise, list of book I have given.
Continue.
2022, 2 SCC 331. Lordship, paragraph 6 onward, Your Lordship. We have hardly learned counsel. Should I read, Lordship?
it has not taken the second Ambika construction into consideration. Anyway, on the basis of this, interest has to be negated. If we are agreeable, we'll negate interest and we'll allow the award. Otherwise, if you want to contest on interest, you come back. On the basis of this judgment, there can be no interest anymore. If we accept that, it's fine. The claim we will not touch, but the interest we have to set aside.
My Lord, can I just...
But I don't know whether the other Ambika has been considered over here or not.
Yes, not.
Because the previous Ambika, paragraph 33 or 35,
Yes.
was completely interpreted in the opposite sense by Justice Chandrachud. Justice Arun Mishra's thing of Ambika was completely interpreted in the opposite. I don't think that is there.
Lordship, can I just seek instructions coming tomorrow? On that issue.
Otherwise, on the claim, we don't think there is much to say.
Lordship will give me little chance of more next day. I will make some more study.
Yes, we'll give you a chance. So we'll keep it next week.
Right, ma'am.
Next Monday?
Next 1 minute, Lordship.
Yes.
Okay.
8 minutes.
The appeal has to be heard.
Next Monday, Lordship, I will be in Guwahati. If it can be posted on 10th.
Very well. At the request of the appellant, let the matter appear on February 10.
10th.
Yes.
Much better.
From the main list, item number 1.
What is this about?
This is the airport matter, my lord. They have submitted the feasibility study reports. The Greenfield Airport.
What is the position? This is the airport.
The new Greenfield Airport project, my lord, for which survey was conducted.
What is the state's view? Does the state want it or does the state not
Your
want it?
Lordship, because ultimately the current airport will not be able to have this bigger aircraft. Though we have entered into agreement with SpiceJet on 14th January, whereby SpiceJet will operate 2 flights from Delhi to Shillong, Barapani, and on 76-seater aircraft, my lord. So we 76-seater aircraft, Bombardier aircraft will be used, and the state government and SpiceJet have entered into contract on 14th January.
Like the previous one, where you will,
yes,
all the vacant seats you will fill up.
Yes, Your Lordship, that kind of arrangement is there. Viability funding gap will be, that kind of, this funding gap will be provided by state government, my lord, to the SpiceJet in case if the number of seats are less than. So that will also give us some idea whether we have got that kind of potential, because SpiceJet has got about 14 Bombardier aircraft, so they will be regular and they have some experience.
What about the pre-feasibility study?
My lord, the study was done, my lord. And after the study, it appears that there are hills, my lord, in the runway area and as well as the approach funnel.
In the other place?
In the new site, my lord, at the new site. To that effect, my lord, the final figures will get what is called OLS survey, my lord. For that purpose, a specialized aircraft comes and it takes measurement and whatever is required, my lord. But before that, because that involves a certain amount of cost. So on the basis of Survey of India's topography sheet, my lord, we have correlated the hills and prepared a chart and handed over to the state to examine whether cutting of those hills. And
How much, what does it involve?
my lord, it involves quite a substantial number of hills, my lord. The charts are here with me.
Then it is like it won't happen.
Because the obstacle in the present one also, because of chopping of the obstacle number 1. Now they're saying numerous obstacles may require to be chopped down, so it might not feasible.
If it's not feasible, it's not feasible. That really can't be.
From Airports Authority, we are not saying that it is not feasible, my lord. What is the scheme, my lord? The government has to take care of the cutting of hills. Now we have given the chart that these are the hills. You estimate what is the probable cost of leveling the land.
If the probable cost runs into several hundreds of crores, then it will not be feasible.
Because what I see, my lord, is that some of the obstacles are 130 meters, 200 meters in the chart which was handed over just now to me, my lord, and there are so many obstacles are there. But I will place it before the government and PW, whichever expert body is there, to assess the.
Very well. The Airports Authority of India reports on places the pre-feasibility report, from which it appears that there are several areas in the surrounding hills at the greenfield site that may have to be leveled, full stop. Paragraph, the AI expects the state to undertake the leveling work, full stop. Paragraph, in a convoluted sense, and without undertaking a more scientific and precise exercise of ascertaining the feasibility of the area, on the basis of topography sheets available from the Survey of India, the AEI has rendered its opinion, full stop. Paragraph, there is no doubt that the leveling work will involve a huge expenditure which the state may not be able to afford. Full stop. However, Learned Advocate General says that the matter will be placed for consideration before both the PWD and the appropriate authorities in the state. Full stop. Paragraph. At the end of the day, it has to be both the state and the union who have to be on the same page for an appropriate airport to be set up in Meghalaya, full stop. The hills here are not as steep or as difficult to maneuver around as the Himalayas to the north, and it is more than likely that a full-fledged, independent airport catering to Shillong and able to host wide-bodied aircraft would give a big fillip to the state, full stop. But it has also to be recognized that it is a matter of policy that involves both the state and the union, and whether or not at the prodding of private agencies in control of nearby airports, if either the state or the union is not keen, no mandamus can issue in such regard. Paragraph. The state also reports that it has entered into an agreement with a private airline for regular service of a bombardier aircraft between New Delhi and Shillong, full stop. A minimum guaranteed amount has been assured by the state, full stop. The state submits that the kind of demand for such flight will help the state assess whether Shillong will have the passenger capacity warranting a larger airport. Full stop. Paragraph. Let the matter appear. 8 weeks hence for both the state and AI to indicate on the progress.
Item number 2.
May I please, Your Lordship, if Lordships would be kind enough to give this matter on after a week's time, Lordship.
You are for the respondent?
Yes, Lordship.
At the request of the respondent, let the matter stand over for a week. Next week?
Yes, Lordship, up to any day. Highly obliged, Lordship.
Yes.
Item number 3.
It's a connected matter, my lord.
Connected matter. Let this matter appear after this, the MCA review petition number 7 of 2022, a week hence. Yes.
Okay.
Item number 4.
My lord, I filed my affidavit, my lord, putting some.
You filed your?
An affidavit was supposed to be filed, my lord.
Very
was
well.
filed.
Yes.
I have received the copy, Lordship.
Yes. What is the matter about?
Yes, Your Lordship, the matter is about, there were 2 advertisements published.
There were 2?
2 advertisements published, Your Lordship. The first one which was withdrawn. However, the application of the first advertisement was accepted for the second.
21st August.
My lord, the teacher's case, Lord. Teacher's case, my lord. Teacher's case, Your Lordship, yes. So, Your Lordship, on the first advertisement, the appellant is still within the age limit. However, the second advertisement was no longer, she's no longer on the age limit, the appellant.
Yes.
So, however, Your Lordship, in the advertisement, there's no specification as to the age limit and criteria, and nothing has been laid down. However, Your Lordship, it has been mentioned required to the qualification also is not clearly mentioned, Lordship. In the
This is a writ petition. Is this an appeal or
It's an appeal, my lord.
appeal?
Appeal. So the main contention was that, Lordship, the appellant is over age during the second advertisement. So examination was conducted and she qualified and she's given the appointment. The appointment, Your Lordship, was made on with one ground that she should qualify
No,
for.
in the second advertisement, the first advertisement was cancelled. You have not arranged any malafide in the cancellation of the first advertisement.
The contention of the petitioner, Lordship, in the court below, is that a chance should be given to the outsiders and the member of the village to take part in the selection process.
Very good. So
that
they
was
issued
given.
a second advertisement.
Yes, Your Lordship.
And so we don't find any malafide in the cancellation of the first advertisement.
Yes, Your Lordship.
Sometimes, to ensure that a particular candidate is not given the opportunity, a malafide cancellation takes place, but that's a question of fact. That's not your case.
Yes, Your Lordship.
Now, as per the second advertisement, was there an age qualification indicated?
No, Your Lordship. No,
If there was no age qualification indicated, how do you say she is over age?
my lord, Lordship, here, my lord, on the last occasion, Lordship had asked me to point out on the basis
Yes.
of what the Red Court came to a finding that she is overage. Now, my lord, in my additional affidavit, my lord, I've enclosed a document which was received on the basis of an RTI, where, my lord, there is a communication by the government, by the respondent authorities to various schools, that the age limit for aided schools will be 35, and with a further relaxation of 3 years for OBC and 5 years for ST. And my lord, Lordship has decided a similar case, in fact,
Yes.
in the writ of Bill Manjushri Datta, if Lordship will
Yes.
remember. In that case also, my lord, the advertisement did not mention a particular age. But Lordship, at the end of
Based on Rule 6 or something of the.
relying on the Assam rules, but my lord, we already had that notification in effect, on the basis of which all appointments in aided schools were made. And my lord, they had relied on one particular appointment where a lady who was 43, belonging to the ST community, was appointed, and on the basis of that, the writ court allowed the writ petition, subsequent to which a writ appeal was filed. So my lord, this case is very similar to that case. Here, my lord, apart from the age criteria also, my lord, the writ appellant does not have MTech, which is also a requirement, my lord, to be appointed as a teacher. And my lord, in fact, in the Indian order itself, it was mentioned that she has given a leverage of getting the MTech within a period of 2 years. I think 2 years is already over, if I'm not mistaken, and I'm not sure whether till now she has cleared the MTech also, my lord. On the other hand, I qualify on all counts.
No. That 2 years can't be read into this because she has to be given the appointment and has to be given the chance. If she has not been given the appointment, she has not been given the chance.
No, but
Therefore, we will go only by age.
My lord.
And by, if they have found MTech, then naturally MTech is better qualified, they'll take the MTech. Are you ready to go on? Do you have a copy of the previous judgment? Where we read
Yes.
that?
I beg your pardon, Lordship.
He is relying on a previous judgment of this court.
I do not have the copy of that.
Just get it from him and
Well.
see. We've discussed it in great detail. There were 3 or 4 names.
Yes,
And
Lordship.
one of them was more than 43. And then we've indicated why it was justified.
Okay, Lordship.
So now, if you're ready, you can come back even tomorrow.
Tomorrow. Day after tomorrow, Steve. Huh? Day after. Day after, will you? Day after, your Lordship.
Day after, very well. At the request of the parties, let the matter appear on
The first one.
first.
Are you obliged?
Item number 5.
My lord, here also this criminal appeal will be taken up after the Komarchand, which is
Yes, yes. Where is Mr. Khan? He had appeared in this matter?
Yes, my lord, today due to some personal difficulty he could not be
Very
present.
well. Let this matter appear 3 weeks hence in the hope that the principal matter in which a host of issues has been raised pertaining to jurisdiction, is decided by then.